I'm here to let you know the decision regarding whether to appeal the not guilty verdict in the matter of the Queen versus Gerald Stanley. Before doing so, on behalf of public prosecutions and myself, I extend every sympathy to the Boushie family as they continue to suffer the loss of their loved one. How sad it is for everyone who knew him and those who will not get the chance to know him, that he is gone far too soon. Now, to the question of an appeal. I'll start by giving you the framework for the decision, a framework set by the Criminal Code. The Crown can only appeal if the court made an error about the law alone. The Crown cannot appeal a disagreement over the facts, the interpretation of witness evidence, or because a particular perspective leads to the opinion that the verdict was unreasonable. The Crown cannot appeal because some people have questions about how the investigation was done or what the lawyers did. The Criminal Code clearly states that the Crown can only appeal legal errors in the course of the trial. Practically speaking, in reviewing a jury trial, the primary issues are whether the judge made an error, a legal error, as to procedure, or on a point of evidence, or, as this was a jury trial, in the charge to the jury. Questions about the appropriateness of established procedures, such as how a jury pool is constituted or the peremptory challenging of prospective jurors, are matters for others. Not just any legal error will permit an appeal either. The error has to be one that might reasonably have made a material difference to the result. So says the Supreme Court of Canada. And prosecutions cannot use public resources to appeal unless there is a reasonable likelihood of success. Finally, I stress that public prosecutions is independent and acts in accordance with its legal duty. In this instance, that duty is to make sure only legitimate, legally viable appeals proceed. And we approach it in that way to prevent personal views, political influence, pressure groups, or anything other than the rule of law affecting the assessment or being perceived to do so. Public prosecutions lawyers, me, lawyers who do the appeal work here in Saskatchewan, experienced trial lawyers outside the appeal section, have applied the framework I've described and found no basis to appeal. Therefore, there will be no appeal. It appears there have been some calls for an appeal simply because of the particular verdict, or wishing to send a message about inclusiveness. The Criminal Code does not allow an appeal for such reasons. The question at the trial was whether or not the jury, on the evidence as presented in its entirety and on the judge's instructions, was unanimously sure Mr. Stanley was guilty under the law. Larger social issues and the shape of criminal procedure were not questions for them. If there are concerns about the police investigation, those should be directed to the police. If there are concerns about the prosecution, those concerns should be directed to me at public prosecutions. I stress, though, that those concerns must point to specific errors before they will be examined. To say something could have been done better or differently with no specifics and without demonstrated knowledge of the case gives no cause to think anything was improper or inadequate. A word now about how the case was prosecuted and had to be prosecuted. The role of the prosecutor determined that, as it should in every case. and the Supreme Court has said what that role is. And I quote, "It cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly. The role of the prosecutor excludes any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings." So that is what the Supreme Court has said is the role of the prosecutor. Now, the Crown concluded to the end that there was a reasonable likelihood of conviction. The prosecutor pressed the case. But to ensure that people are only convicted when a separate trier of fact is sure of guilt, the prosecutor is not and cannot be the judge. Regarding the defense, defense counsel are tasked to bring the best case they can on the law and the facts. Defense counsel should not be faulted for using procedures available to them or putting forth the accused perspective. I expect anyone listening to what I'm saying would, if charged themselves, expect as much from their lawyer. If there are questions about what the code allows and why it allows that, those are to be raised with the federal government. Now, as I indicated earlier, there is no basis for concluding the judge said or did anything to justify an appeal. There is no basis to fault him for discharging his duty, rightly focused on the legal issues as required by the criminal code and the case law. Next, a few words about the jurors. As I said before, the criminal code governs jury procedures. Who is chosen is not up to the jurors. They did not seek their role. It is both a civic duty and a truly honorable thing to take on that responsibility with commitment to the process and sincerity of heart. There is no evidence that anything other than the trial evidence and the judge's instructions guided them to their unanimous verdict. To presume that because a jury chose a particular result, they, all 12 of them, must have acted improperly does them the greatest disservice. It hints at turning the justice system into a servant of an agenda instead of the means to determine whether a crime was proven. And it risks discouraging others from doing their duty in the future. As to the differing views on the proper composition of juries and the reasons for those views, the subject can be debated elsewhere. The Supreme Court, though, has already spoken. And I quote, "It must be remembered that the right to a representative jury is an entitlement held by the accused that promotes the fairness of his or her trial in appearance and in reality. It is not a mechanism for repairing the damaged relationship between particular societal groups and our criminal justice system more generally, and it should not be tasked with that responsibility." End quote. Again, whether the law about jury procedures needs to change is a matter to take up with elected officials. The criminal justice system is aimed at determining whether or not a judge or jury can be properly sure, satisfied beyond a reasonable doubt, of a person's guilt. So, moving forward, public prosecutions remains committed in each instance to proceed wherever there is a reasonable likelihood of conviction and the public interest calls for it, regardless of who is the complainant and who is the accused. I urge no one to be discouraged or distrust the system. We are all in this together and must be united against crime and in the search for justice. Complainants need to come forward when they have been wronged. Witnesses need to come to court and testify, sharing the truth. Good men and women will convict where they are sure it is right, but regardless of the conclusions in a particular case, only if we all stand up and help the police, help the courts, can we discourage and defeat crime. That is how we achieve justice and safeguard us all. Back to this case. I know there is much sadness over the decision not to appeal. And that is unfortunate. But there can be no appeal because the law does not allow it. If you disagree with the law, debates about how the law ought to be need to happen outside the criminal courts with respectful dialogue while we all recommit to the duty we share to participate when the justice system calls. Thank you. Now, as Drew indicated, I have time for a few specific questions in regards to the appeal decision.
On the appeal decision, then it just came down solely, and I take it was you and discussions with others solely based on the judge's instructions to the jury. Is that the right way of surmising this? In a jury trial, that's really where an error of law might occur?
No, it's a little broader than that. Certainly the instructions are a focus, but evidentiary rulings, procedural matters, and so on all play into it. So it's part of the larger trial. We look at the whole thing.
Do you mind, and perhaps you feel you can't speak to it, but it just seems, and I don't wish to paraphrase you, but I would suggest in my 15 years of reporting here, it's quite unprecedented to have someone in your position as high up as you are within public prosecutions to be doing something like this, to have to lay out what the Crown, what the jury, what the defense does, and any I guess, conclusion by people, there may have been an agenda by any one of those groups in this case.
Well, I certainly wasn't attributing an agenda to any particular group, and certainly not to those that I listed. But we have here in this case a matter that is of interest to everyone in Saskatchewan and beyond Saskatchewan. And it's important that the justice system be as transparent as possible. Certainly there are times when prosecutions can't answer questions. There are matters of discretion and so on where we can't talk about it. But when we make this decision, we want people to understand how carefully it's considered, that it is a principled decision. It's not something based on a whim, or it's not something done off the cuff. We want people to have faith in the justice system, and to explain it to them strikes me as a fundamental way to achieve that.
You said that if anyone has any complaints with the prosecution of this case, they should come to you. Have you received any complaints yet?
Whether or not I've received any complaints is something I'm not prepared to comment on. Thank you, though. And certainly if someone has a concern, as I say, we want to hear it. We may not agree, but we need to hear from